The 5-year rule gives the government the authority to seize your home. And the vast majority of seniors do not discover this until it is far too late to take any meaningful action. If you are 65 or older, if you own your home, if you have any amount of savings whatsoever, you need to fully understand exactly how this rule operates, because the very professionals who are supposed to walk you through it have a very powerful incentive to stay silent. There is one specific legal document that can halt the entire process before it ever gets started, but most estate attorneys will not bring it up unless you ask for it by name. I will tell you what that document is called before this video ends. The rule itself is known as the Medicaid 5-year lookback, but the name is deceptive. It is not truly about looking back. It is about penalizing you for actions you took when you had absolutely no idea you were doing anything wrong. Here is how it functions. If you ever require long-term nursing home care, and the average stay in this country now costs over $18,000 per year, you will almost certainly exhaust your funds. As a result, you will be required to apply for Medicaid to cover the expenses. But before Medicaid pays out a single dollar, a state caseworker will pull every bank statement, every property record, and every gift you have made over the previous 60 months, every single transfer, every check written to a grandchild, every vehicle you signed over, every dollar you moved. They then calculate a penalty. The penalty is not a monetary fine. It is something considerably worse. The state takes the total value of everything you transferred during those 60 months, divides it by what they refer to as the regional penalty divisor, which in most states falls somewhere between $10,000 and $12,000, and the result becomes the number of months you are locked out of Medicaid coverage entirely. During those months, you are required to pay for the nursing home out of pocket at over $9,000 per month, even though the very reason you applied for Medicaid in the first place is that you do not have $9,000 per month. This is the trap. You transferred the money away, therefore you cannot pay the bill. But because you transferred the money away, the state will not pay the bill either. So who ends up paying the nursing home? The nursing home does not care who pays. They will take legal action. And the very first asset they will pursue is your house. Most people assume the rule only applies to large transfers. That assumption is incorrect. The look-back period captures everything. A $400 holiday check to your granddaughter counts. Covering the cost of your son's wedding counts. Helping a grandchild pay for college tuition counts. Forgiving a loan made to a family member counts. Selling your vehicle to your nephew for $1 counts. Even charitable donations beyond a certain threshold can count, depending on which state you live in. There is no birthday exemption. There is no holiday season exemption. There is no exemption for simply not knowing the rule existed. The federal annual gift tax exclusion, which currently sits at $19,000 per recipient, has absolutely nothing to do with any of this. That is a rule that belongs to the IRS. Medicaid is an entirely separate system governed by its own distinct rules, and Medicaid does not care what the IRS permits. A gift that is completely lawful under federal tax law can still trigger a full Medicaid penalty period. Most seniors do not grasp this distinction. As a result, they assume the gifts they have given are protected. They are not. Now here is where the situation becomes significantly worse, and this is the part that has the power to financially devastate families long after someone has passed. If you are married and your spouse enters a nursing home facility, you might assume the law shields the healthy spouse who continues living at home. There is a protection in place. It is called the Community Spouse Resource Allowance, and in 2026, that allowance sits at $157,920. That is the maximum amount of countable assets the at-home spouse is permitted to retain. Every dollar above that figure must be spent down before Medicaid will contribute a single cent toward care. $157,000 may sound substantial until you consider what it actually needs to cover. Property taxes, home repairs, Medicare premiums, groceries, transportation, prescription medications, and unexpected emergencies for the remainder of the healthy spouse's life. which could easily span 20 years. That works out to roughly $657 per month. That is the financial reality the state expects you to manage on, while your husband or wife is residing in a facility billing over $9,000 per month for that exact same period of time. But surely the house is safe. The house is the one thing they simply cannot take away. That is what nearly every senior across America believes, and that belief is incorrect. The house is considered exempt while you are alive and residing in it. Therefore, Medicaid will not compel you to sell it before you qualify for benefits. But the moment the Medicaid recipient passes away, a program known as the Medicaid Estate Recovery Program is activated. Federal law mandates that every state attempt to recover the full cost of care from the estate of any Medicaid beneficiary who was over the age of 55 at the time those benefits were paid out. The primary recovery target is the house. The state files a formal claim against the estate. The heirs are then informed that they must either pay the outstanding balance in full, which frequently amounts to hundreds of thousands of dollars, or sell the home and hand over the proceeds. The average estate recovery claim in this country now exceeds $74,000. In certain states, that figure surpasses $200,000, and it is not a matter of choice. It is not open to negotiation. Federal law requires the state to pursue the home, so the house your parents promised would be passed down to the grandchildren ultimately ends up being claimed by whatever state they happen to live in. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older statute on the books called filial responsibility. These laws hold that adult children can be made financially liable for the unpaid nursing home bills their parents leave behind. For many decades, these laws sat dormant and largely unused. But beginning in 2012, after a Pennsylvania appeals court ruled that a nursing home facility was entitled to collect $93,000 from an adult son to cover his mother's care costs, that changed dramatically. As a result, the threat is not simply that the state reclaims your house. The threat is that the nursing home facility, after the state finishes its own recovery process, can then pursue legal action against your children for whatever balance remains. Here is a real-world example to illustrate how this plays out. A widow in Ohio, 78 years of age, transferred $45,000 to her daughter across a 4-year period. Birthday gifts, holiday checks, some financial help with a car repair. Nothing she considered to be out of the ordinary in any way. She entered a nursing home facility in month 47 of those 4 years. The state divided her $45,000 by the Ohio penalty divisor of $7,160 per month and locked her out of Medicaid eligibility for 6 full months. The nursing home billed her $9,200 per month for each of those 6 months. The total bill came to $55,200. She did not have the funds to cover it. The facility placed a lien against her home. She passed away 8 months later. The state then filed an estate recovery claim for an additional $140,000 in care costs. Her daughter received a formal letter informing her that the home she had grown up in was being ordered to be sold by the court. There is a strategy that some specialized attorneys employ to limit the damage when there is very little time remaining. They refer to it as the half-a-loaf approach. The concept is that if you or your spouse already requires care, you transfer away half of your remaining assets and use the other half to personally fund the care during the penalty period that the transfer triggers. It preserves something. It is meaningfully better than losing everything, but it demands precise timing. It requires the involvement of a highly specialized elder law attorney, and it must be executed before the Medicaid application is submitted, not after. Once the application has been filed, that strategy is no longer available. The seniors who end up losing everything are almost never the ones who took the time to plan ahead. They are the ones who were never told that planning was even an option available to them. They sat in a hospital room, signed a power of attorney, and began writing checks directly to the nursing home with no awareness that a single phone call to the right type of attorney just 2 years earlier could have fully protected the house, the savings, and the inheritance they intended to leave behind. Now, I told you at the very beginning of this video that there is one document most estate attorneys will not raise unless you ask for it by name. Here is exactly what it is called. It is called a Medicaid Asset Protection Trust in 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont. There is also a legal instrument called a Lady Bird deed, which accomplishes a portion of the same protective goal specifically for the home. To be more precise, a Medicaid Asset Protection Trust is an irrevocable trust. You transfer your house, your savings, and your investments into the trust. You no longer technically hold ownership over them. The trust does, but you retain the right to continue living in the house. You retain the right to receive income generated by the investments. The one thing you cannot do is withdraw the underlying assets back out once the trust has been active for 5 years. Those assets are no longer counted by Medicaid during the eligibility determination process. The look-back period cannot reach them. The estate recovery program cannot reach them. The house is fully protected. The savings are fully protected. Everything held inside the trust passes directly to your heirs without passing through probate, without being subject to estate recovery, and without being touched in any way by the state. The reason most attorneys do not raise this option is straightforward. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to establish correctly. A standard will cost around $200. The senior walks into the office asking for a will. The attorney prepares and sells them a will. And the conversation about long-term care planning never takes place. This is precisely why you must walk into that office already knowing the right phrase. You must say the words Medicaid Asset Protection Trust out loud. You must ask directly whether you qualify, and you must do so at least 60 months before any care is needed, because the 5-year clock does not begin counting until the trust is actually funded with assets. Here is the specific action plan for this week. First, pull every bank statement from the past 60 months and identify every transfer exceeding $500 made to a family member. Compile a written list. You need to fully understand your exposure before you speak with anyone. Second, locate an attorney who holds a specific certification in elder law. That credential is called CELA, which stands for Certified Elder Law Attorney. A general estate planning attorney is not sufficient for this purpose. You need someone whose entire professional practice is built specifically around Medicaid planning. Third, ask that attorney directly and by name about a Medicaid Asset Protection Trust. And if you happen to live in Florida, Texas, Michigan, West Virginia, or Vermont, also ask specifically about a Lady Bird deed for the home. Fourth, get the trust funded without delay, because every single day you postpone is another day added to the far end of your 5-year clock. Fifth, share this exact information with every adult child in your family, because this rule does not only affect you personally, it affects everything you have spent a lifetime building and planning to leave behind. The 5-year clock begins on the day the trust is funded with your assets. Not the day you decide you should probably plan, not the day you place a call to the attorney's office, but the actual day the assets are transferred into the trust. Therefore, the single most costly day of your financial life is the day after you should have already begun.